Okay, welcome everyone. We're delighted to have Professor Evan Fox-Descent with us today from McGill University Faculty of Law. Evan or Even?
Evan.
Evan, yeah. Okay. Evan researches the area of legal and political philosophy, the rule of law, administrative law, human rights, and he writes a lot about fiduciary duties in the international legal context, and has a forthcoming book on international law and the fiduciary constitution of sovereignty with Ibn Credel, and talks a lot about law's legitimacy in his article, so it's going to be a very stimulating discussion. With us also is Professor Hanoch Dagan from Tel Aviv University, who's a Stuart and Judy Calton Professor of Legal Theory and Innovation, our former dean, and my former teacher. And Professor Dagan has written extensively on property theory, contracts, restitution, and unjust enrichment, and has recently published a book, Reconstructing American Legal Realism and Rethinking Private Law Theory. So we're looking forward for a very stimulating discussion. Please.
Well, fabulous. Thank you very much, Doreen and EL, both for organizing this fabulous conference, and of course for inviting me. Evan Credel and I, as Doreen mentioned, are working up a book manuscript tentatively titled International Law and the Fiduciary Constitution of Sovereignty. So many of the challenges that face any trusteeship model we encountered a few weeks ago when we had a workshop and invited some folks in to give us their comments on the draft manuscript that we have underway. And one of the comments that we received from a colleague of mine from political theory in McGill, Jacob Levy, really sort of stuck with me because it sort of captured a criticism and a concern, I think, that many people have, at least when they're first presented with a trusteeship or fiduciary model of authority. And it's best captured in the quote that I present as the epigraph to the paper for this conference, that perhaps I'll read out, as it sort of sets a challenge, I think, for any such theory, and really the paper that I've sent around is an attempt to address this challenge. But let me just first read this quote, because I think it's so pointed and so lovely for the sake of getting a conversation going that begins with a critical approach to trusteeship as a public idea. So it's from C.S. Lewis, and of course we don't have to care for his theological apologetics, I don't think, to get the gist of the quote from his book God in the Dock. It says, "Of all tyrannies, a tyranny sincerely exercised for the good of its victims may be the most oppressive. It would be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep, his cupidity may at some point be satiated, but those who torment us for our own good will torment us without end, for they do so with the approval of their own conscience. They may be more likely to go to heaven, yet at the same time likelier to make a hell of earth. This very kindness stings with intolerable insult. To be cured against one's will, and cured of states which we may not regard as disease, is to be put on a level of those who have not yet reached the age of reason, or those who never will, to be classed with infants, imbeciles, and domestic animals." All right, so there are the gauntlets thrown down in fairly clear terms. How can we think of trusteeship and the idea of a trusteeship that does not treat its purported beneficiaries as imbeciles or domestic animals, as obviously none of us wish to do? Well, with that, with these ideas in mind, the paper sets out, and it's wonderful. I really appreciated the questions that Yale posed at the beginning of the conference, because two of them are the same questions essentially that I ask at the beginning of this paper. The first is essentially, can the trusteeship model avoid the problem of the moral busybody. I mean, it's kind of the question of, does it make sense does this model make sense in the public sphere? And the second question then is the more normative question, which is simply that even if in principle we can avoid this problem, should we take this model seriously given its apparent propensity to lend itself to abuse? And so in the paper, this is a paper written by myself and someone who's been just a fabulous research assistant for both me and for Reverend Criddle for the past 2 years, Ian Dahlman. What Ian and I try to do is look at what we take to be possibly the hardest case for the trusteeship model. And this hard case is the case of Indigenous peoples who live within sovereign states, settler states that purport to possess and exercise legitimate sovereign authority over Indigenous peoples who themselves may entirely reject the authority of the state. How can we make sense of the state's legitimacy and its claim to legality vis-a-vis these peoples? So we think that the Indigenous case is a hard case for two reasons. Essentially for two reasons. One is the history of colonialism, which in large measure was justified using ideas of trusteeship and guardianship. This forms the second part of Ian and my paper, and I'm not going to speak to it. I'm not going to speak to it because we're very fortunate to have a full paper with us that we're going to hear from later today by Andrew that frankly does a richer and more nuanced job of taking us through the challenges that any such trusteeship model will face, given its dark and lengthy history of being put to colonial purposes. But there's a second reason that I think the Indigenous case poses a hard case for a trusteeship model, and that reason comes from the nature of Indigenous claims. Indigenous peoples within sovereign states are not liberal individuals who are seeking to be recognized as free and equal and making claims on the basis of having individual rights to be recognized such that they're recognized as free and equal citizens. Rather, Indigenous claims, paradigmatically, are collective or communal claims. They're special claims to lands. They're special claims which they view as territory. They're special claims to use lands, even if they are not Indigenous territory per se. And most significantly, in many cases, they're claims to sovereignty, or a kind of sovereignty. They're claims to have decision-making authority over their ancestral lands. Now, David, ribbed me saying, well, this question of who decides, isn't Evan just turned into some kind of, wild-eyed Schmittian? The context of the question I ask about who decides is the context of Indigenous peoples on the one hand and sovereign states on the other, both making claims to have sovereignty over the same territory. And so what distinguishes the question here of who decides from Schmidt's question is that Schmidt, of course, presupposes a more or less homogeneous nation state where the who decides question identifies which public actor is best suited, or just is the actor, depending on whether it's Schmidt describing or Schmidt prescribing, the best actor to speak for the vote, the best actor to make the friend-enemy distinction. So that's not what's going on here. That's not what's going on when we ask the who decides question here. The question that we're asking when we ask who decides here is whether can we overcome imperialism and an ongoing bloodless conquest of Indigenous peoples who find themselves within sovereign states that resist recognizing the collective communal claims they make to their own sovereignty. So I don't think David's an imperialist, of course, but this is how the who decides question that I ask on page 15 that he points to should be interpreted. Okay, so after we go through the disgraceful history of Western colonialism in all too short shrift, the paper has two further sections. One of the sections is a section called pluralizing sovereignty, and this goes through the development of international law in two ways, or across two trajectories, let's say, with respect to indigenous peoples. Now, its early development basically mirrors or replicates the kind of trusteeship as colonialism paradigm that Andrew I trust is going to speak to us about this afternoon. And so this begins with the Berlin Conference in the late 19th century. It continues through the League of Nations and the mandate system, where indigenous peoples are viewed as peoples who cannot stand for themselves, and their welfare is committed to the members of the League of Nations as a sacred trust of civilization. The ILO at this time also becomes involved in regulating work conditions in the colonies as well as in Western states. And in 1957, the ILO drafts a convention called Convention 107 that seeks to protect indigenous peoples' rights. But it does it within a framework that is integrationist. That is, it seeks to protect indigenous people's rights so far as indigenous individuals can be viewed as liberal individuals, so rights against discrimination, rights to association, to expression, to religious worship, all the sort of standard civil and political rights, but all with the aim of integrating indigenous peoples into dominant Western society. That is, all with the aim of eliminating indigenous peoples as such. So in the decades following the drafting and implementation of Convention 107, there was criticism of this integrationist policy as the indigenous movement started to gain steam in the late 1960s, 1970s. There was discussion of drafting a new convention that would not adopt an integrationist policy. And those discussions through a working group at the UN, an ILO working group at the UN, eventually led to Convention 169. And Convention 169, again, is a result of a negotiation between representatives of indigenous peoples on the one hand and state parties on the other, but it tries to the extent that it can within the negotiated framework that had state parties pitted essentially against indigenous peoples, develop what commentators will typically refer to as a paradigm of legal pluralism. So the legal pluralist aspects of Convention 169, one of them, for instance, is a recognition, a fairly fulsome recognition of indigenous law. That is, indigenous customary law is understood to have effects, legal effects with respect to indigenous peoples within indigenous territories. And as well, there is, of course, in Convention 169, a discussion of what happens when the state wants to do things on indigenous lands. And this is really the hot point of the law that governs indigenous peoples, domestic and international law that governs indigenous peoples, and their relations with sovereign states. What happens when a sovereign state wants to do something, develop a hydroelectric project, give a permit to a private company to extract natural resources from indigenous lands that could have a very deleterious effect on those lands and the peoples living there? Well, in the lead-up to Convention 169, indigenous peoples had a very clear position. They were like, well, we think we have our own sovereignty within sovereign states, and that should be respected. And so if you want to come onto our lands and do these sorts of things, you need to get our consent. States resisted this across the board, and they resisted it for the very obvious reason that if indigenous consent were necessary, that would give indigenous people a veto over state projects that might even have the imprimatur of legislation. In other words, it would give indigenous peoples, with respect to actions on their lands, co-legislative authority. It would turn the state, in other words, into a kind of federal state where indigenous peoples have a certain legislative authority that sits beside the authority of that rests beside the authority of the sovereign state. So states were naturally resistant to this, and so what we get in ILO Convention 169 is a kind of compromise position. States were willing to say, yes, we should consult with indigenous peoples, we should take their interests into account, but we're the state, we're the sovereign actor that has sovereignty delegated to us from international law, and when it comes to deciding what can happen within the territory of the state, we have to have the final say. So with that view of the states on one side and the indigenous view on the other, the compromise position that was the compromise principle that was adopted was a principle that states have to consult with indigenous peoples, but with the objective of reaching an agreement or obtaining their consent. With the objective of reaching an agreement or obtaining their consent. Now, fast forward a number of years. So Convention 169 was ratified in 1989. Fast forward a number of years, the Indigenous movement continues apace. There's a lot of activity at the UN general level to develop a declaration with the view of forming a convention later. And a few years ago, in 2007, the Universal Declaration on the Rights of Indigenous Peoples is passed by the UN General Assembly. And this declaration, its advance over Convention 169, is it declares formally that indigenous peoples do have a right to self-determination. That was not established. In fact, it was Convention 169 even said that the reference to peoples here in this convention is not meant to have international significance. That is, peoples in international law have a right to self-determination. So the use of peoples in Convention 169 was accepted from that meaning. In the UN Declaration, there is a forthright recognition of the self-determining capacity of indigenous peoples. Moreover, we get a principle of how indigenous and non-indigenous peoples are to relate together that comes much closer to giving indigenous peoples the right to have their consent obtained. This, under the UN Convention, the duty of the state now is to consult with indigenous peoples in order to obtain their free, prior, and informed consent. Now, this is not quite what indigenous scholars and activists will sometimes refer to as a full, so free, prior, and informed consent. It's sometimes referred to as an FPIC duty. It's not quite an FPIC duty or a duty to get the consent of indigenous peoples, because states can always say, well, we consulted in good faith, we did what we could. They wouldn't agree, and so anyway, we're going ahead with this plan to develop a hydro project on their territories. We're going to involve them, they're going to get some benefit, but the bulldozers are rolling. So that's one. So in terms of the international positive law, that's one trajectory that we trace in the paper. The other trajectory that we trace, and in many ways the trajectory that's much more interesting, is the implementation of this law and another international legal instrument in practice within the jurisprudence of the Inter-American Court of Human Rights. So in 2001, the Inter-American Court of Human Rights first recognized that indigenous people had certain land rights, and in the past 6 years, in 2007, there was a case called Saramacca Peoples out of Suriname. 2 years ago, there was a case out of Ecuador called Quechua of Sarayaku, and these cases are very interesting because they try to deal with this question of what are the obligations of a state that wants to do things on what's clearly recognized as ancestral indigenous territories. In Saramacca Peoples, the court came to the conclusion that intrinsic to the legal regime that we must assume exists between indigenous peoples and the state through the duty to consult is the requirement that indigenous peoples are entitled to effective participation. Of course, it becomes an open question as to what effective participation will amount to, but effective participation in a project, They're also entitled to receive a reasonable benefit from the development of the project, and the state has to conduct an environmental impact assessment and make the findings of that assessment known to Indigenous peoples prior to them engaging with the state in negotiations toward how they're going to benefit share in the development of the project. So that was within the context of the state's duty to consult. But what really broke new ground in Saramacca peoples in 2007, and to my knowledge, this is the first time that a judicial body has come to such a ruling, is that they found that if the state is involved in a large-scale project on ancestral lands, a project that could threaten the physical or cultural survival of the indigenous people there, then in fact their consent is required. Their consent is required. And with all of the implications that come with this. That is, with the implication that where consent is required, Indigenous people, in effect, have a co-legislative capacity over those lands. In Sarayaku, the Sarayaku case was a case that basically resulted from essentially a 10-year war. A 10-year, almost something, approaching a civil war between the Sarayaku people and state authorities, running from the late 1990s into its final resolution in 2012, where Ecuador had granted a Argentine oil company a permit to explore its territory, explore and expropriate. Or not expropriate, extract oil from the territory, and the oil company has started to do this without consulting or getting the consent of the Sarayaku people at all. The result of this, when it finally went to the Inter-American Court, was the court saying, "This is, you didn't even comply with the most basic duty to consult. These activities are illegal as a consequence," and Ecuador was held liable and found to owe damages of millions and millions of dollars to the Sarayaku people. What was most significant about the case is that the elements of the duty to consult were the rationale for them were framed in a way that presupposed that Ecuador had to get the consent of the Sarayaku. That is, Ecuador had to consult early so the Sarayaku would know whether they wanted to approve the project or not, and Ecuador had to explain the risks and benefits of the project. Again, this was justified by the court in terms of giving the Sarayaku the ability to know whether they really want to be involved or approve of this project or not. Now, in the last portion of our paper, Ian and I say that what's really interesting about this, from the perspective of sovereignty as a trusteeship of humanity, is that it extends the model in two novel directions. Whereas on the classic sort of international model that Yale's developing, we think of sovereigns as trustees for humanity with respect to foreign nationals, and in that case, we'll typically say that states have weaker and presumably fewer duties to foreign nationals. Here, there's a vertical dimension where Indigenous peoples are citizens of the state, but because of their special situation, they're owed more and thicker or more extensive duties as a result of their vulnerability, as a result of their history, and the special claims they have within the state, and their ability to make certain collective claims. So that's a sort of vertical dimension that's exposed by the Indigenous case. But perhaps more radically and even more interesting is a horizontal dimension where we have what Ian and I describe as constitutional pluralism. Jean, of course, defends this kind of a paradigm in her book at the international level, and the idea is that implicit within the jurisprudence of the Inter-American Court and one reading of the positive law is a sharing of sovereignty. So there isn't just one sovereign who applies legal principles within a state. There are, in fact, multiple sovereign entities. The state's one of these, but Indigenous peoples may constitute other sovereign entities. And for these individuals, these sovereign entities to be able to relate to one another under conditions of legality, their claims and their contests have to be reviewable by some sort of independent body. Now, that may be a national court, but in the Inter-American case, it's resulted that the court of final recourse has been the Inter-American Court of Human Rights. And so we think that this is appropriate. And one of the nice things about this this jurisprudence is it helps to respond to the question with which we begin the paper: is does the trusteeship model necessarily turn into a model that has the trustee acting as a moral busybody? Here we say no, because sovereignty is not simply applied to individuals, but where those individuals have collective and communal claims to make, sovereignty is in effect shared with them in a kind of co-federal way. Now, I know I just have a moment or two left, but I do want to just talk very quickly, reflect very quickly on what this might have to how we would track this across the structure that Sergio very helpfully related to us today. That is, that sovereignty can be understood as having ascending and descending dimensions. Well, the ascending dimension, the sort of ground-up view that Ian and I defend, and Evan Criddle and I have worked on as well, is that the trusteeship relationship itself is constitutive, and in its constitutive nature, regulative of relations between sovereigns and the individuals subject to them. So we look at trustee relations or fiduciary relations generally for pointers as to how the state and individuals are to relate to one another. But there's also a sovereignty from above dimension, a descending dimension, and this is where international law plays a role. International law identifies some actors internationally, but not others, as sovereigns. And what's interesting about the Indigenous case is that whereas leading up to and then after World War I, we have the subjects of international law being expanded to include individuals with the human rights movement, with the Indigenous movement, what we see is the persons or the agents of international law who possess sovereign or sovereign-like powers seems also to be expanding and can be interpreted as expanding through the kind of the structure that we get from this model. And finally, I would just say, reflecting on some comments that Jean made earlier, that the model does presuppose that there are different dimensions of legitimacy. One dimension we might think of as legal legitimacy. This is the legitimacy of the state that applies, as David just the way David suggested, that applies and is sustained to the extent that the state maintains legal order consistent with principles that we take to be intrinsic to legality. And then there's political legitimacy, which for most of us, of course, is democratic legitimacy. Right? That is the sort of we the people legitimacy. So I'll stop there.